environmental law. We're into week 11 of term 3, 2019. Thank you very much for those of you that have joined us for the live session, second last session. If you haven't joined and you're watching this as a recorded session, why not come in and say hello next week for our final session? I'll be elsewhere, so the background will be a little different, and next week we'll be talking about the final take-home paper, going through some of the more important aspects of what we've covered this unit, and provide you with some more tips. There'll be a few tips tonight as well. Now, you may have seen the information guide about the take-home paper for this year. If you haven't, please access that through Moodle. But you were able to see that. I think I sent it to everyone. Thank you. So just a few pieces of relevant information regarding that take-home paper. Of course, you know that it's released on Thursday, 13 February, which is Thursday of next week, isn't it? Week 12. And it's due Friday, 14 February at 11:45 p.m. Now, for those of you that have taken the day off from work or study or whatever it might be, you'll have plenty of time. If you haven't and you've got commitments elsewhere, then think of the take-home paper as a substitute to an invigilated examination. In an invigilated examination, we provide you with 2 hours to complete a task, and of course, the 2 hours requires you to handwrite during that time. Many of you, I'm sure, are much quicker typists than you are at handwriting. So that alone is an advantage of a take-home paper. But I think if you allowed yourself 3 or 4 hours, that should be plenty, provided you've undertaken some preliminary preparation and you are conscious of the sort of work that we're going to cover in that exam. I've already given you a huge hint in that exam, and Karen says typing's much more legible. Yes, thank you. So with the take-home paper, you're required to answer 2 questions, both worth 25 marks. The limit on both is a very miserly 1250 words. It's not many words. I think the maximum word limit is 2,000 words. I know that doesn't add up, but just remember that sometimes you need a little more words on one question than you do on another, if that makes sense. All right, so in question 1, I present you with a hypothetical scenario, requires you to reflect on the work that you've undertaken. This can be from anywhere during the unit, and I always urge you to consider a number of aspects. So it may be legislation, case law, of course, being the 2 primary sources of our law. It might be principles, so we're looking at, for example, international principles, treaties, obligations, things of that nature. They may have filtered through into our law. We'll be talking, you may want to refer to procedures or regulations or rules. Practice directions, for example, may become relevant, and we'll talk about some of those this evening. So when you answer a hypothetical scenario question, particularly one that's problem-based and court-based, as this one will be, then please consider broadly what it is that the court wants to know, or the advice within the court context. Now, the second question is an essay-style question, but it's in 5 parts. Each is worth 5 marks. So there's 250 words in total, making 1250. And I may revise the total maximum word number from 2,000 up to 2,500 so that it actually does add up. And I'll make that change known to you if I do make the change. But obviously you need to work to a short deadline. This is all part of the task. Those of you that may have seen past papers will know that in environmental law, on one occasion, I gave students 3 hours to complete a take-home paper, and students seem to respond to that well. So I'm not sure if giving you so many hours is a good thing or a bad thing, but let's hope that it's a good thing. On other occasions, for those of you that may have done alternative dispute resolution with me, you'll know that in one take-home paper, I gave everyone 5 days. But that was a special type. So it can vary. This one you've got 29 hours, but the expectation is that you find maybe 3 or 4 hours. If you've got more than that, great. Please ensure that you upload your work in the usual manner. That is, you undertake your work in Word, upload in Word, not PDF, please, and make sure that you upload through Moodle in the usual manner. I do expect you to reference in accordance with the Australian Guide to Legal Citations, 4th edition. So this is unlike an invigilated exam where you can get away with shorthand. This isn't like that. You need to reference in an appropriate manner, and that will be part of the assessment regime. Importantly, this is an individual assessment. However, you can discuss it with your colleagues. In other words, it's a major departure from an invigilated examination where it's no talking. Here you can talk with each other if you wish. So it may be advantageous to have some sort of study group. But remember, of course, that it's a fine line. What you can't do is collude. You can collaborate, but you can't collude. So you can't act together to cheat or plagiarize or engage in academic misconduct. Now, given that it's a fine line between collusion and collaboration, I'd suggest that you undertake a little bit of research on that topic, and the university has its academic information, and we might even touch on that a little next week. Right, any questions so far about the take-home paper? All good? All right, well, I'll continue. If there are some questions, please let me know as we proceed. So, a very important aspect of this particular paper, and I can't stress this importantly enough, is there are no extensions allowed. And this is not an assessment where you receive a deduction for late submission. There is a cut-off, and the system will cut you off from submitting. So please don't leave it until the very last moment. Give yourself a little bit of breathing space to give yourself some comfort on that. If you should encounter a difficulty, you may need to apply for some sort of special exemption, which is still possible in the same way that it would be in an examination. And to prove the difficulty, perhaps send me an email. I may not respond at 11:30 p.m, but you get the picture. But my advice is please do upload your work on time and don't consider an extension. This is one where it very much is in some ways a replacement for the exam where you have to be at the centre at the time and on the day required. Now, the first question is for a hypothetical client. And I'm not telling you whether the client is, I don't know, an environmental activist or an environmental group or a council or a state government or a developer or a mining company or whatever it might be, but someone that's involved in the process of this environmental law dispute. Your requirement is to generate some appropriate options, explain the options, draft and advise. So at the very least, you should have your template for an advice set up, ready to go. Please ensure that you have the basics. You know, the very first thing I look at is the overall presentation. Does it look the part? Part of that is, does it have the same font consistently throughout? Does it have headings? Are there superfluous spaces? Is there something just off about the document, like it's extremely cramped or it's extremely spread out? Is it paginated? All of those sorts of things that go to the overall basic look of the paper. So spend a little bit of time, if you haven't already done so, developing a template that you think looks the part, that looks very professional. We'll refer to some documents this evening that might give you some guide as to how you might set out, for example, a submission, which you could readily adapt to set out for an advice. Now, here's the really good hint I ask you to carefully consider two sample cases. So these are sample cases that I flagged at the start of term. So I think in the assessment section or the assessment ribbon of Moodle, you'll see a reference to Booth and Bosworth and Fraser Coast Regional Council against Byrne Brothers. We're going to deal tonight primarily with Booth and Bosworth, and next week we'll deal primarily with Fraser Coast Regional Council against Byrne Brothers. You need to read that material carefully and do some undertake some work around both those cases and the work that's involved in it. Has everyone had a look at those cases and the materials yet? Hopefully that's a yes. If not, please do so this week. Now, the second question, the essay style question in 5 parts, involves a legal concept, if I can use that broad term, but one that I've mentioned on many occasions during this unit. So there won't be any surprises, I hope. What that means is that if you believe that I've mentioned a legal concept or a number of legal concepts regularly during the course of this unit, then you can half prepare some of your answers, can't you? You can consider how to explain this legal concept. You can consider where it's sourced, how it's used, where it's relevant in decision making, by whom it's relevant in decision making. You know, all those sorts of things. How do courts approach decisions? What type of decisions are made? What type of courts deal with this legal concept? Are we talking state, we're talking federal, or does it cross the borders? Is it something that's dealt with at council level, state government level, or at federal level? Or is it across all of those borders as well? Is it executive? Is it judiciary? Is it both? You know, so you get the idea. So if you can identify a legal concept that we've considered on many occasions and start to flesh it out, that would be an excellent way to start preparing for the take-home paper. All good? So let's now start to talk about the week 11 content. You know the philosophy I've tried to adopt and put into practice in this unit. The philosophy is you have your textbook. It's very, very good. It's very authoritative, but it's huge. And unlike some other units where I ask you to very carefully read every chapter, you'll note that I haven't done that this term. There's just too much reading. So my idea with the textbook is that it's more a reference guide where you select the material that you want. If you've read it all, that's fabulous, but you won't need it all, of course, for the take-home paper. But it's there primarily as a reference source. And what we've tried to do is introduce the theory, but always within a practical context, so that hopefully at the end of this unit, you can say, well, I've got some idea of how all this works in a practical way. So tonight, with that in mind, the topic is challenging environmental decision making, and we're looking at this theory from a practical perspective, and that is from the perspective of community litigants. So an important part of the process of challenging environmental decision making, and one that almost immediately comes to mind at the commencement of litigation for environmental law, is the alternative dispute resolution process. And you'll see in the material, practice directions, etc., that there is a reference to the way in which, or ADR is used in a very real way, in a practical way, in resolving environmental law disputes. Now, if, as I say, we're looking at the issue of challenging environmental decision making from the perspective of community litigants, can anyone tell me perhaps the very first source that comes to mind that deals with this in a practical way? And I think Sean and I've got an email. Sorry, I've got a I've got a, yes, Andrew. No, I think I uploaded a video with Sean Ryan from this office. All right, so the organisation I'm thinking about is the Environmental Defenders Office, in particular in Queensland, and I'm going to attempt to share the screen here. I do hope this works. And hopefully now you can see a screenshot of the Environmental Defenders Office. Is that what you see, Karen? That's what you see? All right, thank you. Okay, so brand new news, court win over Adani's North Galilee water scheme. So if you haven't looked at this website, please do so now. It can be potentially very important for you for understanding the process and also for your, potentially for your take-home paper. The ribbon legal information is particularly useful, and I'd recommend that you consider the fact sheets section. If you look at the fact sheets, it will have information about some of the matters that we've dealt with already in this unit and something that we're dealing with in particular for tonight. So for example, this fact sheet on appealing, enforcing development approvals and seeking declarations is potentially important for what we're talking about tonight, and it will certainly be important in the context of what we're talking about next week when we wrap up, when we talk about the Byrne Brothers decision. That's one of the sample cases that we're talking about. So that's an important resource, and you'll see there on the screen, hopefully, the fact sheet that deals with appealing, enforcing development approvals and seeking declarations. Okay. The other resource that you might want to consider is the Environmental Law Australia website. So environmental law, and the reference is envlaw.com.au. Now, Environmental Law Australia is an organisation that provides case studies of environmental litigation. It has simple explanations of environmental law in Australia, and it also includes information and documents about public submissions and other documents such as applications, pleadings and outlines of submission. So if you look at this website and you click on the link Case Studies at the top, you'll see some important commentary in relation to a number of key cases and high-profile environmental law disputes. Now, if you're looking down the page, one of those might catch your eye as being particularly relevant. There's a couple actually that we've talked about in this unit, but I know I've flicked through very quickly. But did anyone spot something? Come in on the chat facility if you saw something interesting there. I know I'm moving fast. I'm trying not to give you a headache. Anything interesting come to mind?
The Flying Fox case that you're just scrolling past.
Yeah, that's the one. That's the one that you might want to have a look at, because that's Booth and Bosworth. So under the heading of Flying Fox case, you'll see that it has information about the action that was brought by Dr. Carol Booth, why she brought the application, what it was all about, and very importantly, it deals with the significance of the case, the legislative reforms that came about. And here's a great resource. On the website Moodle page, you would have seen that we have reference to some of the key documents, and here they are. And they're broken down into the areas of practice. The application statement of claim, the amended defence reply, then the documents relating to the interim injunction and the trial with referral to the ministers. So that's where it becomes ministerial in nature. All right, so I'll just stop the share now. So if you haven't already had a look at that website, please do so. It's very valuable information. Any questions? All good? But you would have noticed some others, the Paradise Dam case. Those of you that have watched all of the uploaded recordings will know that I've got, amongst others, one with Sean Ryan from the EDO. There's one from Roger Curry, who was the activist in relation to the Paradise Dam case, which is also on that website, and some interesting material elsewhere as well from QCs and judges. All right, when it comes to dealing with environmental litigation from the perspective of community litigants, one of the key aspects that you need to consider is the issue of injunctions. And of course, you need to consider whether we're dealing with an injunction application in the federal jurisdiction or the state jurisdiction. And of course, you've got to determine that as a threshold question, because if we're dealing with this as a federal dispute, then of course you need to look at the EPBCA and consider the injunction provisions under that Act. So given that Booth and Bosworth was a federal matter, let's consider injunctions from a federal perspective. But first, just a quick recap. In the context of environmental law, injunctions are used to restrain people from undertaking activities that might cause environmental harm. That's kind of the primary purpose. That's the main reason the injunction process is there. We call that a prohibitory injunction. Prohibitory meaning that it's required to stop a respondent from undertaking some form of action. It's, if you like, the court equivalent of chaining yourself to the tree or the bulldozer, so to speak. The injunction might also be a mandatory injunction. A mandatory injunction is one where it requires someone to take positive action. Mr. Miner, you must stop, or you must unlock the chains or do something positive, is a mandatory injunction. And applicants usually in environmental law litigation will ask for temporary or interim injunctions. And the idea of that is to prevent degradation of the current situation, if you like, the environmental status quo. So generally speaking, the purpose of the injunction application is to stop someone from doing something, and the reason put forward is to maintain the environmental situation so that the court can ultimately decide the case before the matter, the subject matter of the action disappears. So the application might be for an interim injunction or interlocutory injunction, as we sometimes say. If you're asking for that type of injunction, we covered this last week, so we'll test your memory a bit here. But what do you need to establish to the satisfaction of the court in general terms before you can obtain your interlocutory injunction? And I'm looking for two things here. Standing, yeah, that's a good point, Thomas. It wasn't actually what I was thinking, but you're right, it's critically important. So let's assume for a moment you've got standing, but you're right, Thomas, that's a preliminary thing that I should have mentioned. Let's assume that you've got standing. What do you need to establish to the satisfaction of a court in order to obtain your injunction? I think we covered this in the interview with Sean Ryan, so it's probably worth looking at that video if you haven't already done so.
So,
yes, Sarah?
That you must establish that there's a case to answer and that the injunction is reasonably necessary on the balance of probabilities to prevent harm going on while the case is under
That's it?
decision?
Yeah, that's it. That's great. Thank you very much. So initially you need to establish that you've got at least an arguable case. If you like, another term might be a prima facie case. And at the same time, you need to show that there is a serious question to try. So you've got to show your credibility. Assuming you've got standing, You need to get your foot in the door, so to speak. Judge, I do have the evidence, enough evidence here to establish that I've got a case. I'm in with a chance with the arguments that I wish to put forward. And what I'm asking you to do is to stop something, because I've got a serious matter here that needs to be tried before the court. So you've got to have an arguable or prima facie case within the context of having a serious question to be decided. And then once you've undertaken that part, as Sarah quite rightly points out, you need to establish that there is the balance of convenience
John, your mic's cut out. We can't hear you.
Can you hear me now? All right. Sorry, I'm not sure what happened to the headset. Maybe I ran out of charge or something basic like that. But what we need to do then is consider these two aspects. Do we have a reasonable argument, and is the balance of convenience in our favour? Can anyone tell me, specifically within the EPBCA, the section number that you might consider if you're looking to argue for an injunction based on a contravention of the Act? Any thoughts? I'll have to start counting you in. You just got in time, Thomas, before the countdown started. 475, that's correct. Thank you very much for that. If you have your screen available to look at that, please do so, but I'll share the screen as well. So section 475 is important because it outlines the basis upon which someone can apply for an injunction based on a contravention of the Act. So if a person is committing an offence or otherwise contravening the Act or the regulations, then a number of people may apply to the federal court for an injunction. The minister, of course, or an interested person other than an unincorporated organisation, or a person acting on behalf of an unincorporated organisation, that is, an interested person. Now, was it Thomas who correctly identified the issue of standing? If you look at subsection 6 of this section, it contains the definition of interested person in the context of individuals, and subsection 7 looks at the concept of interested persons from the perspective of an organisation. So if you're providing advice to someone that is interested in seeking an injunction, there is the issue of standing, and that's where you'll find the answer. Then it's a question of asking for an injunction. Now, what type of injunction will you ask for? It may be, and most commonly would be, a prohibitory injunction, and you'll see the heading there, which deals with subsection 2 or subsection 2 of 475. It may be that if you ask for a prohibitory injunction, there are additional orders that are sought, or it may be that you seek a mandatory injunction, which is subsection 4. Then, of course, subsection 5 deals with the issue of interim injunctions. And we understand now what that means in the context of something which is done on the way through prior to the final hearing of the matter. So if we consider the case of Booth and Bosworth, we have 2 reported decisions, one that, and possibly more actually, but the 2 that I want you to consider are firstly the reported decision in relation to the application for the interim injunction, and that's citation Booth and Bosworth 2000 FCA 1878. You'll find this in a number of sources. I just happened to have brought up the Ostley version, and you'll see the citation there. Now, of course, we all know that this case dealt with the issue of flying foxes, and it did involve the application by Carol Booth to restrain Mr. Roland Bosworth from engaging in conduct that Dr. Booth said constituted an offence or contravention of the EPBCA. And Dr. Booth sought an order of the court to restrain Mr. Bosworth from causing or procuring or allowing the death or injury through electrocution, shooting or otherwise, of flying foxes on Mr. Bosworth's property. The principal allegation, the application rather, was for the prohibitory injunction and an order that in the interim, before the matter is heard formally, Mr. Bosworth dismantle the construction and devices on his property that were used for killing flying foxes by electrocution. So you get the picture. In this case, even though nothing has been finally decided, Dr. Booth is asking the court to order Mr. Bosworth to dismantle the devices on his property. They're quite extensive. Now, of course, the issue of standing, as Thomas points out correctly, we need to consider first. So how did Justice Spender deal with that in this instance? If we look at paragraph 5 of the order, you'll see that the court said, I am satisfied that Dr. Booth does have standing to bring the proceedings and does have standing to apply for this interim injunction. It's apparent to me that the doctor is well known in the flying fox population, as it appears from the evidence that the doctor is employed as a policy officer for Worldwide Fund for Nature Australia, does volunteer work, is a secretary of the Magnetic Island Nature Care Association. She has cared for young flying foxes that have been orphaned, etc. So based on that evidence, Justice Spender in this case was satisfied that Dr. Booth was an appropriate person to have standing. What about the legal issue? Now, if we look at the case, we need to remember, of course, that in order to apply for the injunction, Dr. Booth would have to show good prospects of success regarding the substantive matter before the court, and the substantive matter before the court related to section 12 of the EPBCA. So let's have a look at section 12 for the moment, and then I'll come back to the interim order decision. So section 12 of the Act says that there are certain requirements for approval of activities with a significant impact on a declared World Heritage property. And in this instance, the substantive matter related to an alleged breach of section 12 of the EPBCA on the basis that Mr. Bosworth was taking action that would have or likely have a significant impact on World Heritage values of the heritage area. The interesting thing about this is also that it refers to penalty units. And penalty units, you need to go to the Crimes Act, Commonwealth, Crimes Act 1914, and look at section 4, Cap A, which deals with the issue of penalty units. Now, I'm not sure, I think the penalty units currently are $180 or maybe $200, somewhere in that order per penalty unit. So you can see that if it is, for example, 200, and I'll get the calculator out now, for a body corporate, 50,000 times 200 is $10 million. So we're talking substantial maximum penalties. So that's section 12. That was the principal argument, or the principal argument was based around section 12. Now, if we go back to the case, we need to ascertain what is the principal dispute all about. If we look at paragraph 10 here, the court says the central question in this application is whether the action by Mr. Bosworth satisfies the elements of section 12. Does it have a significant impact on the World Heritage values of the heritage area? So that's a question that needs to be determined at the final trial. But for the purposes of the interim application, we look at the evidence, and the evidence in this case is primarily encompassed in paragraph 16 of the decision, where Justice Spender says that the evidence from the applicant is that after a complaint from a member of the public regarding the killing of flying foxes on the farm, Dr. Bosworth went to the farm. She investigated during the evening of 22 November 2000, and they left the farm at about 7:40 p.m. They'd seen about a dozen flying foxes already dead on the electric wires. And later that night, they drove past and saw a spotlight beaming on an airborne flying fox and heard a gunshot. She went to the same grid wires previously and now counted 61 bodies. On row 1, 12 freshly dead bodies on the ground and a live juvenile, which was videotaped. Then left the property at about 6:40 in the morning the next day. So that's the basic evidence that Dr. Booth collected in order to convince the judge, at least at this stage, to grant the interim injunction. The parties both brought expert evidence, which the judge described as impressive expert evidence, and that included senior lecturers from universities. Now, ultimately, the court declined the interim application for the injunction. And the technique that His Honour used in this case was almost Sirac. By that I mean, at paragraph 2, His Honour said, "Here is my conclusion," and then went on to say, "Here are the reasons why I've come to the decision that I have." So it's very typical Sirac type drafting. The court said that the interim injunction is rejected. The evidence is contentious. It hasn't been tested by cross-examination. And the object of the orders is to hold the fort, or at very least, ensure that the evidence is available to be appropriately tested. So the court explained that while there are matters put forward by the evidence and they're of great importance, they're more properly answered at trial. And the court noted the potential financial loss to Mr. Bosworth, which he'd be unable to recover at trial. So on the balance of competing interests, the court declined to make the interim injunction order. All right, so I'll just stop the share there for a moment. So that's what happened in the interim injunction application. So now you know the section, you know, the thought logic, you know, the type of arguments that were put forward, you know, the type of evidence that was presented, you know, the impediments that in the minds of the judge as to why he should or should not have granted the order. Any questions about that? All good? All right. Let's move on to the primary case then, which is Booth and Bosworth, and the citation, and I'll share the screen now, is 2001 FCA 1453. You should see that case, and I'm using the unauthorised Ostley versions. Remember, of course, if you're preparing an examination, you'd normally go with the authorised reports. Now, in the primary case, the court concluded that it had a discretion to grant an injunction. So remember, of course, that an injunction can be sought on an interim basis, interlocutory injunction, or a permanent injunction. And the court identified in this case that on a permanent basis, it does have a discretion to grant the injunction that was sought by Dr. Booth. The respondents had not provided certain evidence. Ultimately, the court concluded that an injunction restraining the operation of the grid should be made. The action of the respondents in operating the grid did constitute a contravention of the Act. There was no approval in place, and the injunction was a conditional one. The person authorised to grant such approval was the Minister for the Environment. So what I'll do is I'll invite you to read the documentation which relates to that case. And you'll see this as the application, the statement of claim, defence reply, the outline of submissions. Probably an interesting one from your perspective would be the outline of submissions. Now, I'm not sure if that's up on your screen now, but I'll just check, and actually I'll stop the share. I'll reshare. We'll have a look at the outline of submissions for the interim injunction, for example, and I'll do that now. This is useful for a number of reasons, because it provides a clear statement of the arguments that were used for the interim injunction matter, but it also provides you with a good template in terms of the way to set out submissions for, in this case, the federal court. But the way in which submissions are set out is typically very similar, regardless of which court you're dealing with. Now, of course, those of you with a keen eye would know that I've picked up that this document was not paginated, but we'll overlook that little matter for the moment. So that'll give you a good idea of what you should look for and how you might set out your documentation. And we've referred to the primary case, the 2001 FCA 1453. There is a footnote to this decision, and that is in the decision of Bosworth and Booth, 2004 FCA 1623. And I'll just share the screen with you now. There were a number of farmers affected by this decision, and the injunctions, as we know, were granted in the final decision. So in this case, Bosworth and Booth, one of the farmers, Mr. Bosworth, applied to the federal court to have the injunction removed, and the matter came before Her Honour Justice Kiefel, as Her Honour was then. Of course, she's now the Chief Justice of the High Court. And if you look at paragraph 8, it provides some commentary as to the thinking of Her Honour in this matter. There was no basis for a new trial. The process is one that has already been undertaken. And paragraph 9 says, any alleged lack of application of the EPBCA should have been raised in the earlier proceedings. So part of Mr. Bosworth's application was look, the EPBCA shouldn't have been used, it shouldn't apply. And Her Honour said, well, you should have raised that at the appropriate time, don't raise it now. And she referred to the issue of issue estoppel, more particularly Anshun estoppel, which those of you that have studied civil procedure and evidence will know as being relevant in these circumstances. Okay, so that's all that I propose to talk about specifically for Booth and Bosworth. Any questions, comments? All good? All right. Now let's just, before we wrap up, have a change of pace slightly. We've been talking about the federal jurisdiction pretty much all evening, but I now want to go back to have a look at how these sorts of things are dealt with in the state jurisdiction in Queensland, the Planning and Environment Court. So before you consider acting or advising a party to take action in the Planning and Environment Court, you need to have a look at the P&E website, familiarise yourself with the process. And remember, of course, that the Planning and Environment Court in particular encourages all parties to engage in alternative dispute resolution. So let's have a look at the, I suppose, the starting point on the website for the P&E Court in Queensland. I'll share the screen. And you'll see there courts.qld.gov.au, Courts, Planning and Environment, going to the Planning and Environment Court, and almost immediately you'll see the reference to alternative dispute resolution and how to use ADR in P&E court proceedings. It also has good information about actually starting the proceedings, and then goes on to talk about the hearing and the review process. So the P&E court, through its ADR process, has certain powers, and these powers are determined by reference to the legislation. You'll notice that the registrar has certain power to conduct case management conferences or mediations, without prejudice conferences, and chair meetings of experts. When we talk about chairing meetings of experts, we're really talking about what's called an experts conclave. Really interesting procedure where the registrar or the ADR practitioner, in a way, mediates between the experts, and the idea is very, very targeted. You know, ultimately, what matters do you agree upon? Let's list them. What matters do you disagree upon? Let's list them, so that the court can get straight to the key issues. That's what we mean by a meeting of experts or an experts conclave. Now, I mentioned the importance of practice directions, and we're almost finished for tonight. You've been very patient, but I do urge you to look at the practice directions for the Planning and Environment Court. There aren't many. Many of the practice directions have been repealed and replaced. So, for example, the case management procedures, which are now practice direction 2019, number 1 of 2019, that repeals the case management procedures direction from 2018, and the 2018 version repealed an earlier version from, I think, 2014. So when it comes to the practice directions, I particularly urge you to look at these, the 3 of them: case management procedures, which is practice direction 1 of 2019, power of the ADR registrar to make orders or issue directions, which is practice direction 2 of 2019, and the Planning and Environment Court early resolution of or determination of infrastructure charges and development approval conditions, which is number 7 of 2013. And you'll be very pleased to hear that that's just about it for tonight. Before we wrap up, do we have any questions, comments? Are we all good? Everything fine? All right. Well, thank you again. I've mentioned earlier off camera briefly that I'm well advanced in marking the second assessment. I hope to have those marks to you with some feedback at an early stage. And I want that to be as early as possible so that you can prepare better for the final take-home paper and know where you're at. There are some students who haven't yet uploaded their work. If you're watching this as a recorded session and you're one of those few, there's only a few of you, please upload your work as soon as possible, because it does give me a better opportunity to release all the results and the feedback for everyone. Okay, we'll see you next week for our final session. All the best. Bye then.